extension if necessary and leave 10 minutes to my learned junior, Muthoni Nyuguto. The documents we have filed are written submissions dated the 22nd of June this year with 2 annexures. Digest of authorities dated the 22nd of June this year. Bundle of authorities dated 22nd June this year. All 3 bound in green. 4, proposed Amishi brief adopted by High Court, which appears on page 1072 of the AG's record, volume 3. Finally, written submissions dated 9th March this year with 2 annexures appearing at page 1016 in volume 3 of the AG's record. Those are our documents. If it may please the court, constitutions exist to limit the exercise of authority, and this does not appear to be understood or taken into consideration by the executive in Kenya, and indeed by many state entities and state officers. And it is clear to me that modern dictators, especially in Africa, are using the Constitution or constitutional amendments as a special purpose vehicle to claw away on civil liberties and democratic gains. And we have examples all around us, even in the sub-region, where extension of presidential terms through constitutional amendments have been happening. The point I'm making, my lords, is that while pretending to observe the Constitution, the political elite will use amendments, constitutional amendments, to ensure that they extend their stay in power and concentrate power in their hands. It is our humble submission that this is a consideration that this court ought to put in mind when evaluating this case. The Constitution of Kenya 2010 recognized the danger of this behavior by the political elite. And if you look at the history, which is the CKRC report attached to the Attorney General's record and has been cited page 74 to 76, you will see the fears Kenyans had in the making of the Constitution, that the political elite would mess with the 2010 Constitution much more the way they had messed with the Independence Constitution through hyper amendments. This history is important in evaluating what is happening. When my learned friend, Mr. Senior Counsel Orengo and Senior Counsel Amolo were here, they were happy to state they were part of the constitutional review. I would like to say that I have lived that history too. Throughout the formal process, the more than 20 years of search for the Constitution, and during the tail end, as a member of the Parliamentary Select Committee with my learned, my friend Senior Counsel Orengo, and part of that time as the Minister of Justice. And I want to refer the court to the Constitution of Kenya Review Act, 2008, revised in 2009, and in particular to Section 23, which spells out the function of the committee, to Section 31, before 31 to Section 29, which says what materials the committee would use. And why I'm doing this, because the court has been told that the Constitution of Kenya 2010 is a political settlement. It's quite clear from the mandate given to the Committee of Experts in that act. What the Committee of Experts was doing was to rely on all the documents, all the views given by Kenyans, and to resolve the contentious issues, and to ensure that the review process faithfully reflected the will of Kenyans. So when we are told that it's a political settlement, far from it. It actually reflects the will of Kenyans, and yes, there were political settlements in Naivasha. And those settlements related to the system of government, to the form of devolution. I'll mainly talk of those two and say that even in resolving the political system, as part of the group in Naivasha, we did not go beyond the suggestions given to the Committee of Experts. We just picked the presidential system from among the three options: hybrid, parliamentary, presidential. So even that was not far from the wishes of the people. And I know that the political party I lead and several others had actually presented to the COE for a presidential system. So even that choice was influenced by the views of Kenyans. It was not merely the wish of politicians. And devolution, having picked the presidential system, we adopted it to our situation to be devolution in a unitary system. So what I'm saying is that this is a process reflecting the dreams and aspirations of Kenyans as stated in the preamble of the Constitution. My lords, in the 2010 Constitution, the judiciary, in Article 1 and Article 159, judicial authority must be exercised for the purposes and principles in the Constitution and shall be protected and promoted. And judicial authority must be guided by the principle that justice shall be done to all irrespective of status. This again is anchored in the Bill of Rights, Article 27, which clearly states that everyone is entitled to equal protection and equal benefit of the law. I'm emphasizing that, my lords. I know you know it, but it is important that we remind all of us that nobody should come to this court with a sense of entitlement, however mighty. Once you enter the doors of the court, you are a litigant just like any other. We are therefore asking the court to ignore all statements that have been made extraneously, some of them predicting the outcome of this case, sounding very much like a team member in a boxing match shouting to the opponent that they've already won before the match has started. We urge the court to take its time to read the submissions and the authorities cited and the proceedings of the Superior Court, and to see that the Superior Court discharged its judicial duties admirably in a well-reasoned judgment and gave declarations pursuant to its powers to interpret the Constitution. It was suggested that before by the appellants that the Superior Court or the High Court cannot give advisory, only the Supreme Court. We have no quarrel with that. The High Court did not give advisory. It made declarations as it's entitled to do. This was a suit seeking declaratory judgment, and the court pronounced itself as required and as it is entitled under the law. My lords, my ladies, I submit that we are yet to fully implement our 2010 Constitution. It's a work in progress. And Kenyans, knowing that the political class may be a hindrance, and indeed it has been, to the faithful implementation of the Constitution, gave to the court powers not only to interpret, but under Article 165, to determine whether anything said or done under the Constitution is constitutional. That is what the High Court was asked to determine under 165, and all they did was to discharge their duties. We urge you, in reviewing the evidence, to come to the same conclusion and to find that the High Court, the judgment before you, is safeguarding the dreams and aspirations of Kenyans. And indeed, it is the duty of this court as the guardian of the Constitution, or the duty of the courts as the guardian of the Constitution, to ensure that it sets beacons, it sets limits, as demanded by the Constitution, of the exercise of authority, not of judicial, but of authority by the political elite. I want to say that this court's powers are not inferior to those of the executive. All the arms of government derive their power from the people. And this court has the final word on the interpretation of the Constitution. Drawing on my learned Junior Mudhomi's analogy yesterday, we invite the court to use its sword to mark the beacons of exercise of power by the executive, and to find that the judgment of the High Court should be upheld and the appeal dismissed. Coming now to the question of the attack on the role of the amici in the High Court, which is ground number 6 of the Attorney General's appeal. We submit that the amici discharged their role of advising the court, of assisting the court, of maintaining fidelity to the law, of being impartial, and this is shown in the submissions of the amici before the High Court, which are on page 1019 of the Attorney General's Record of Appeal, and also the submissions by our clients before this court, which are already before you. We were cited as respondents and therefore came to court as such. But the sum total of our submissions will show fidelity to the law, impartiality, the fact that part of our submissions may coincide with the submissions of parties. That does not make the amici biased per se. The amici are talking of the law as it is and assisting the court mainly to understand the basic structure. And coming to that, my lords, my ladies, our submission is that the basic structure is inherent. It is part of the DNA of any constitution. Whether it has been designed or not, as a matter of fact, every constitution has a basic structure. Ours is no different. And if you look at Article 255, you will see protected clauses, which we submit are part of the basic structure of the Kenyan Constitution 2010. We ask you to be persuaded, like the High Court was, that indeed 2010 Constitution has a basic structure and that the basic structure doctrine is applicable to Kenya. My lords,
yes.
The implementation or the realization of the dreams and aspirations of Kenyans depend on the courts as guardians of the Constitution. It is through pronouncements of the court, without fear or favor, that this country will eventually achieve the transformation envisaged by the 2010 Constitution. We invite you to rise up to your duty, and in Dr. Mudhomi's words, to utilize the sword to slay the monster. And the monster, I dare say, is the monster of impunity, of self-entitlement of the political elite. Indeed, the court must enforce the limits of power as enforced by our Constitution. My Lord, I have something I would like to put to you as an officer of this court. When public officers come before the court, don't they have a duty to be impartial and to actually give the court, to the best of their ability, the issues as they are? And to that extent, can the IEBC come to court to protest on the issue of quorum, knowing very well that they are not fully constituted, knowing that the steps to fully constitute them are under the way? Should they waste public funds, public resources, time and money to come and contest such an obvious point? Should the AG, who ought to have advised the executive and the government to replace the commissioners who resigned immediately, should they waste public resources coming to canvass this point before the court, or should they have considered and said the work is underway? Can the IEBC contest the issue that there is no referendum law, the IEBC and Parliament, yet there is a referendum law pending now before Parliament, meaning that they have already identified there is a gap and they are working to redress it? Yet we hear the Parliament and the Attorney General canvassing, not the Attorney General, but IEBC, canvassing this issue before the court. Is this prudent use of resources? What is the court's role in this? Is this a case where the court should reprimand those officers, those state officers, and even ask them to bear the costs? It is happening too often, where state officers take Kenyans who question as their enemy instead of serving them equally with others. These are the questions that are before the court, and I dare say they demonstrate the impunity which permeates ranks of state officers, the executive, very much of government. We are asking the court to utilize that sword to slay the monster. Parliament delayed the appointment of those commissioners by not passing the law. Can they use their delay to come and ask the court to find otherwise? These are the questions we are asking. We urge the court to dismiss this appeal and to affirm the judgment of the High Court. I yield to my learned junior, Muthoni Nyuguto.
President of the Court, Your Lordships and Ladyships, I am Ms. Nyuguto Muthoni, and in the brief time that I've been given, I'd like to address in brief the issue of public participation, the remit of the Constitution with regards to amendments,